Judges in Texas and New York temporarily barred the U.S. government from deporting Venezuelans jailed in parts of those two states. This comes just after the Supreme Court ruled the deportations can resume, but deportees must be given a court hearing before they're flown away. Civil rights lawyers in the two states had sued to prevent the government from deporting 5 men alleged to be part of the Tren de Aragua gang. The men deny the claims. This all centers on the Alien Enemies Act and whether the Trump administration is using it correctly. For more, we turn to John Deaton, a trial attorney and former U.S. Marine. John, thank you for being with us. To unpack all of this confusion, first off, tell us more about this ruling from New York and Texas and how it relates to what the Supreme Court did earlier this week.
Well, the Supreme Court basically gave the Trump administration a pretty big win because they were using this act from 1798, which has only been used in times of war or when a country is invading the United States. And the Trump administration used it, which bypasses traditional immigration laws under Title VIII of the U.S. Code. And the Supreme Court 5-4 said you can do it, except you can't just arrest them and deport them. You got to give them a fair notice hearing, which could be as little as 24 hours notice in order for them to challenge the deportation. And so it's a big win because the normal process, there's 3 million cases under the normal immigration process, and this gives some teeth to Trump's deportation agenda.
Now, John, take us inside the pushback against the Trump administration's use of the Alien Enemies Act. Critics say that it's not lawful use because the U.S. has not declared war, even though they have declared a war on drugs. How do you respond to that?
Listen, it's a fair response. It's never been used. You know, it was used by FDR to basically put Japanese American citizens in internment camps as well as Nazi members in America during World War II. And the Trump administration, I think they were just saying, listen, let's try to figure out a different way to do this. And so they invoked this act. And it's fair criticism to say it's never been done. But at the same time, it shows you that this Supreme Court is allowing President Trump to have great discretion when it comes to national security measures, immigration, and foreign policy. And so it depends on where you stand in the political aisle. It was a tightly fought case, 5-4. So it was very narrow. But due process matters, and unanimously, even though the court's divided, said you have to have due process, you have to give them a fair hearing, and so that's where we stand.
Well, legal challenges similar to what happened in Texas and New York are expected in other states, so this debate is going to continue. How do you see this playing out?
Well, I think the next challenge is what constitutes fair notice and due process. Will 24 hours be enough? Will 48 hours be enough? Will they be allowed to present witnesses? So we're going to see another ruling go up to the Supreme Court probably in the next 6 months. All I can tell you is there's going to be a lot of litigation about this issue for sure.
Well, we'll be watching it and tracking it. Thank you so much.
Thank you.